If anybody has any question, they can raise, no issue, or it can be raised in the last also. I will stop and then proceed. Okay. So now, as you have seen that it states, shall be deemed to include any question determined under section 144 of the CPC. You should know what is 144 of CPC. 144 of CPC speaks about application for restitution. Some words you may find a little bit harder, but you don't feel it, because once you apply it, you will understand it's not a very harder thing. What is restitution? Restitution means taking back. So suppose if a suit is decreed, and then the party want to set aside or revise the order, or they want to modify. In that case, the court will order that this can be taken back to the file. So for restitution, a person can file application before the court, and in that case, if the court decides on the application whether it can be taken or not, this will be called as an order for application for restitution. So here, if you go back to the definition says an order passed under 144 is a decree. That's what the importance of section 144 in the definition of decree. So if you find 144, the court may make orders, including orders for refund of cost and for the payment of interest, damage, compensation, means profit, in the order of reversal. Okay, reversal means the restitution order. So the restitution order under section 144 should be treated as a decree. So to understand what is 144, I just explained what is 144, but we will be dealing with it in detail later. Now, as I told, the definition of decree stated it can be either preliminary or final. See, in bold I have written over here. So one should know what is preliminary decree and what is final decree. What is preliminary decree? Preliminary decree is nothing but when an adjudication decides the rights of the parties with regard to all of them or any of the matters in controversy, but does not completely disposes of the suit, is called a preliminary decree. So if a suit, in simple terms, if I say, if a suit is not completely disposed of by the court, by its order, it can be called a preliminary decree. And a preliminary decree is passed in those cases in which the court has first to adjudicate upon the rights of the parties and then stay in its hand for some time until the court finds itself in a position to pass a final decree. So what is the determination of rights of a party in a particular case, and whether in all the proceedings preliminary decree and final decrees are passed? The answer is no. Not in all the cases that the court will pass preliminary decree. It will be passed only related to some kinds of suits. Like in a partnership dispute, the court may first examine what are the rights of the partners in the partnership deed. So if the court decides the rights of the parties first, it will pronounce an order regarding their rights. And this order will be termed as the preliminary decree. So likewise in partition suit also, the court will first decide the rights of the parties. And the order made by the court on this aspect will be called preliminary decree. Then the court will proceed to examine further regarding how to make it final. What are the fruits of the judgment one should get, and how the disputed facts are to be adjudicated. After that, it will pass a final decree. So the preliminary decree is a stage for working out the rights of the parties, which are to be finally adjudicated by a final decree. So this is the difference between preliminary decree and final decree. And as I told, it won't be there in all the kinds of suits, but in these kinds of suits, which I have given examples, you may find that the court will pass preliminary decree first and then will proceed for passing a final decree. Like suit for possession and means for administrative suits, suit for preemption, suit for dissolution of partnership, suit for accounts between principal and agent, suit for partition and separate possession, suit for foreclosure of mortgage, etc. So in these kinds of suits, the court will first pass preliminary decree and then will proceed for the final decree. And a final decree is one which completely disposes of a suit, as I told earlier, and finally settles all questions in controversy between the parties, and nothing further remains to be decided. A decree is said to be final if within the prescribed period no appeal is filed against the decree or the matter has been decided by the decree of the highest court. So there are two scenarios. Suppose a decree has been passed by a lower court and it has been appealed before the appellate forum, and further appeal has been filed against that appeal, and ultimately it has moved up to the last court where it can go and it can be finally settled. Then that particular decree can be told final decree. Or there is a situation where nobody files appeal against the decree. So in that case also the decree will be final. So in these two scenarios, a decree can be said to be final. And when court passes the decree, completely disposes of the suit. So these two things are to be taken care of, or rather I may say three things, or two things may club together. Like one, when the court passes the decree, that suit completely disposes of. Along with that, you need to see whether appeal has been filed or not. If no appeal, there ends the matter. This becomes the final decree. And if appeal is filed, the final court where last appeal has been filed and further no appeals are there or no provision for appeal is there, apart from that, then it can also be told it is a final decree. So these are the scenarios where we can call it as final decree. Now you find, as I already brought it on bold, so again I need not explain, but essential elements if you see of a decree, one is there must be an adjudication. Supreme Court in 1983 in Madan Naik versus Anshubala Devi and others held that if there is no judicial determination of any matter in dispute, you should understand judicial determination is the word used. So if there is no judicial determination of any matter in dispute, it is not a decree. So if it happens to be a decree, there should be a judicial determination. The determination must be done judicially by a court. If it is made by an officer who is not a court, is not a decree. This is not a matter of administrative nature. An order dismissing the suit for default appearance of parties or dismissing an appeal for want of prosecution cannot be termed as a decree because it doesn't judicially deal with the dispute. So if a decree to be called a decree, it should be a judicial determination, and that too by a court. If it is not by a court, it cannot be called as a decree. That's what the Supreme Court told in Madan Naik versus Anshubala Devi case. And then the other essential elements are like adjudication must have been done in a suit before the court. It should be in a suit. That also to be pointed out. Then third, it is saying the adjudication must have determined the rights of the parties with regard to all or any of the matters in controversy, and such determination should be conclusive. So these are the essential elements of a decree, if you see, which forms part of the contents of decree. Now I have given some examples for your understanding. What kind of orders can be termed as decree? Because if you find the definition, I told some orders or orders where appeal is prescribed or appeal is made available in the court, those kinds of orders cannot be treated as decree. But at the same time, in these kinds of orders, if order is passed by a civil court, it can be termed as decree. So these are some examples I have quoted over here, like rejection of plaint. It is already told in the definition itself. Rejection of a plaint is inclusive in the term decree. The rejection of memorandum of appeal is a decree. Order for abatement of suit is a decree. Modification of a decree is also a decree. An order setting aside an ex parte decree is a decree. An order dismissing the appeal for non-payment of additional court fee is also a decree. Order for partnership dissolution is also a decree. An order for alimony and maintenance under Section 25 of the Hindu Marriage Act is also a decree. So these are some examples one should keep it in mind. Whereas there are some other examples noted down here which cannot be called decree. What are they? An order rejecting an application for the leave to sue as an indigent person. Suppose a person files a suit for declaring him as indigent person and the court rejects that application. That cannot be treated as a decree. Then an order of dismissal of suit for default, that we already dealt with, because that is already stated in the definition itself and it can be found from the definition itself. Then says an order refusing stay is also not a decree. Likewise, an order setting aside rejection of plaint cannot be treated as a decree. But you may find the order of rejection of plaint is a decree. But the rejection of plaint, if plaintiff set aside, then that order cannot be treated as a decree. So that thin line difference you must understand. And order passed in execution proceedings are not decrees. And an order for res judicata and law of limitation also cannot be treated as decree. What is res judicata? Res judicata I would be dealing in a separate class because we need to understand what is res judicata. So I am not describing over here, but you may be having an understanding because all of you might have learned it in the classroom. And law of limitation also, you know that for any application to be filed before a court of law or an appeal to be filed before a court of law, there is a time limit prescribed, either in the act itself dealing with that issue, or there is a law called a law of limitation or limitation act. So limitation act prescribes the number of days or months or weeks within which an application or appeal should be filed. So an order for res judicata and law of limitation cannot be treated as decree. So these are the things I would like to tell you today. Due to time restraints, I would like to finish off here because as per our timing pattern, we have to finish it by or finish within half an hour. So I am concluding here. If anybody has anything to discuss or rather add something, they can come forward and we can have a short or brief discussion and can wind up.
Thank you, Rajesh. If anybody has any doubts, please you may ask now.
So,
Ah,
sir, would you please explain in short as to what is a preliminary order? It was not that clear to me.
not preliminary order, preliminary decree.
Yeah, decree.
Preliminary decree means a decree passed by a court which may not be finally disposing of the case. What it means is, in a case or a suit for partition, if you understand what is partition, or I may go by suit regarding rights of parties in a partnership deed. You know what is partnership, isn't it? So in a partnership deed, suppose a dispute comes between the partners regarding sharing of profit or regarding some other issue. They may go to the court and say that we have a partnership deed and now we have come before this court with a dispute and this court may adjudicate on that dispute. So in that case, the court will first find or try to find what are the rights available to both the partners, or if there are more partners, what are the rights available to all the partners. So accordingly, the court will draw a decree spelling out the rights of the parties in the partnership or partnership deed. So that will be a kind of adjudication where only the rights of parties are taken care of, or the court has come to the conclusion of rights of parties. But the dispute still remains. The dispute may be the sharing of profit or liability, something else. So now, once the court decides the right of the parties in the partnership, court will again further proceed with what the dispute is and how to resolve that dispute, or what can be its final outcome. So after deciding as to the rights of the parties in the beginning, then the court proceeds for the final one. So in the beginning, when the rights of the parties are decided, court will draw a decree, and that decree will be called a preliminary decree. And as I told, the concept of preliminary decree and final decree is not there in all the suit and proceedings. It is there only with some of the suits. And examples I have already shared, like in partnership or in partition, like that, suits, it will be there. Drawing a preliminary decree first and then proceeding for the final decree. Means there will be two decrees in a suit. The suit for partition or suit for partnership, like suits, will have two decrees. The court will draw two decrees or write two decrees. One will be called final preliminary decree, which will be the determination of rights of parties, and then the final decree, where ultimately the dispute will be settled.